name is Sami Mahroum, Director of Public Policy at Oliver Wyman, based here in the UAE. Some of you might have known me from my earlier work and days working in Abu Dhabi on technology and policy. I'm delighted to be here. Thank you for the invitation, and I'm very pleased to be in the company of the esteemed panelists today. We just had a lunch together, and we were contemplating the challenge that that was put to us today with the timing of our panel discussion, because a lot of the topics that we were planning on talking about have already been discussed earlier in the day. So with such a very broad and vast and important topic, we still found it a little bit challenging to go beyond what has been discussed earlier today. Nevertheless, we owe the title of this session, which is on globalization, global and reimagine, plus emerging tech and the judicial system. So again, pleased to be with you. They have been the panel members have already been introduced, so that can save us some time. Let me first perhaps start with a broad question addressed to all the panelist members here. Perhaps I'll start with you, Mamuka, which is about how global really is this phenomena of the integration of emerging tech, especially AI and blockchain, in the judicial system of individual countries. Because when we say global, we tend to generalize on the experiences that are happening in the global north, so to speak, and in advanced economies. But we know that not everywhere in the world is as technologically advanced and savvy as the case is in the more advanced economies. We know that they lag behind from a resources perspective, from an infrastructure perspective, and from a perhaps even illegal framework perspective. So knowing where you come from, working for the EU global anti-money laundering facility, AML, I had to learn this abbreviation earlier today, but knowing all your long experience and history working across countries, especially with countries that lack in resources to jump on the emerging tech wagon, your experience in general working with these countries.
Thank you so much. It's really a pleasure to be here, back to Abu Dhabi, and I'm really grateful to organizers for this extraordinary event. It was mentioned, and when I got this invitation, I really, got some skeleton of thought what I would talk about, and then since morning I'm attending the sessions here, and everything I was planning to share with you has been said. It was perfectly mentioned. And then I also ChatGPT'd it, and everything my plan was also you could be found in the LLM. So I thought what could be done, what can be something of added value, and that's only from my experience what I can share with you in this regard. So as it was mentioned, I am working for European Union, European Commission's Foreign Policy Instrument tool, which supports up to 55 jurisdictions at the moment in doing some, in overcoming some deficiencies when it comes to financial crimes and money laundering and terrorist financing issues. And we are doing with all topics related to AML safety. We are doing with all the actors, starting from private sector, banking sector, regulators, civil society, media, and our main, let's say, client is a penal channel. So penal channel which and institutions of penal chains that are dealing with financial crimes. And of course, you all know and we all know that globally the biggest problem is we have a lot of criminal cases opened, many investigations taking place, and to compare with these numbers, the number of adjudications, number of court decisions where criminals are sent to prisons is extremely low, and there is a huge discrepancy there. So what I can tell you, and let me from the outset say that I fully share what just been said at the previous panel by His Excellency, and also another honorable judge at one of the morning sessions, and I'm quoting judges. Judges is the most difficult, let's say, for judges, it's most difficult to accept something that is totally new. And let's face the reality, what we are talking here is a new one, is really new. So keeping in mind what has been said at the previous sessions. There are some limitations, there are some risks, threats. There's always will be a human factor present, but we also know that AI is giving a huge advantages. And let me give you only 2 examples, and then I'll stop there. What we have noticed, judge, unless it's a specialized court in a country, during his life tenure will be dealing with maximum 2-3 cases of money laundering, maybe not even single case of terrorist financing. So it's less incentive when you have a lot of work. There you have less incentive to follow, developments, follow regularly developments in other countries, etc. That's why AI provides us and provides judges with fantastic opportunity to, gather these new developments without spending too much resources, too much time on this topic. And the second point is again about judges, you have to have some access to information that is available elsewhere. There is no, and there are some constitutional provisions in many countries where a judge can ask financial expert, because financial crimes, includes a lot of figures, for judge not very happy, to have these financial documents, accountancy documents, look at the numbers, figures, which is not so interesting maybe and most probably. So they can ask expert to attend the court session and give advice, but they are, in most cases, they are sometimes even constitutionally prohibited on using this expertise during their deliberations. And during their deliberations, they cannot have this information because they are not accountants. That's why, again, here comes AI, which provides with the support. And just to finally answer my question, and sorry for a bit prolonging my intervention, is that you mentioned most important part. UAE, here it's very easy, but we are working with countries like Republic of Moldova, Sri Lanka, Jamaica, countries which don't have so much resources. How authorities, regulators can provide justice system with reliable, even procurement issues are making an issue here because it's all about good governance. So we need to somehow support and try to also ensure that AI, LLMs, and every other tools, every other algorithms provided are reliable and could be trusted. Again, keeping in mind that still human factor, judges' importance, personal decision based on their judges' belief still will always remain important and necessary. Thank you.
Thank you, Mamuka. I will still have to come back to you regarding the asymmetries in the absorptive capacity of the different countries in implementing these different technologies. Perhaps, as a follow-up on this, Professor Oreste Polosino, you've been working on the different regulatory regimes, so to speak, between U.S., China, Europe. It's very important when we talk about the globalization of the use of this different emerging tech in the judicial system, to factor in that they're not all interoperable, right? They're not all, they follow different legal traditions and different laws and codes of law. How do you reconcile the globalization of technology versus the continued regionalization of law?
Yeah, thank you very much. First of all, it's a great pleasure to be here. I am learning a lot. And the question, it's crucial, because in a way, the question is the following. How is possible to reconcile a global technology with local values? This is very, very important. If you think we have a good, a bad example at the same time in the European Union. In the morning, there was a section about the European Union Artificial Intelligence Act, the first legislation about regulation of AI. Very ambitious, very, in a way, riskful. Why? Because there is something called Brussels effect that worked in the GDPR. What is the GDPR? The European Data Protection Legislation. In 2018, there was a legislation adopted by European Union that in a way was taken as a model in the other parts of the world. No? There was a migration of constitutional ideas from Europe to the other parts of the world. Now the question is it possible to have a reloaded Brussels effect for AI? It's possible, in a way, to export this kind of regulation in the other parts of the world? My answer is a great no. Why? Because every country, every regional area has its own local values according to which now today there is a race to regulation. What does it mean, a race to regulation? It means exactly that there is not one country that is regulating and the others are waiting and seeing, doing a kind of pick up of the best models. No, it's not a cherry-picking exercise. It's a contextual exercise. What does it mean? It means that we have to find a way for a common language, for a universal language. Okay, I know what you are thinking. Universal language means something very vague, very superficial, not always. It means something different. It means multilateralism, meaning that through negotiations, through compromise, it's possible to find a common position. If we count on the migration of constitutional ideas, even worse, European constitutional ideas. I come from Europe, so I am proud of my roots. But I know that such constitutional traditions do not work, for example, for this country, do not work for the United States, do not work for China. And it's the opposite for, United States or China towards European countries. So, which is the route? Maybe the road is a kind of compromise through multilateralism where you have to find two main, and I will close, two main points. The first point is protection of fundamental rights. Protection of fundamental rights, it's important. Otherwise, there is not credibility, there is not legitimation. But on the other hand, it's very important to not hamper innovation. Otherwise, the problem could be that Europe, for example, will become a very, very interesting regulatory point, but without being an innovation point. This will be a real suicide.
All right. Well, thank you. Thank you. I have a few follow-up questions. I'll come back to you about it. David, you work for one of the most prominent legal firms in the UAE, okay? UAE is a very open economy, it's an internationalized place. People who live here and businesses come from all over the world. What kind of lessons or learnings can you really learn, acquire, achieve from what's happening around the world, in other jurisdictions, in other countries, that can help you infuse new methods, new frameworks, legal frameworks, obviously, to support an economy and a judicial system that is very internationalized in its very DNA?
The UAE Federal Ministry of Justice, we know, is looking closely at a range of different countries, as are the court systems in each of our emirates. And you really can evaluate the different countries by two criteria: the breadth of the services which are digitalized, and then the depth, and how far up or down the value chain the systems go. So if we take an extreme example, Estonia, which was mentioned before, with a population of about 12% of the UAE, has effectively one of the broadest digitalized judicial and court systems with extreme depth as well. Very small population, a limited number of disputes by definition, but they've been able to embrace breadth and depth. Singapore, the same. They have 6 different e-justice platforms, and His Excellency mentioned that in the previous session. So they're the high watermark. Singapore has a population of about half of the UAE. Contrast another example, Finland. Finland has about the same population as Singapore, a little bit more. And whereas it has moved to digitalize the court system as such, it hasn't quite got to the point of that applying for practitioners and for parties. And there's a pause and a deep reluctance to introduce artificial intelligence into writing of judgments. And if we look further abroad, there are different countries like India, which has developed a range of different companies that are servicing the judicial industry and automating a significant number of disputes. And in the Indian context, 175,000 cases with a 65% saving in time to a resolution, an average of 45 to 60 days until the matter's resolved. Again, a huge population. They're looking at depth, but not necessarily breadth. If you look at Australia, if you look at Colombia, Brazil, they've tended to automate the consumer disputes, divorce, probate. They're going for a more narrow regime, but trying to do it more deeply. And then Canada is extreme. Canada now has a tool, Justice Bot, which actually helps in the reasoning analysis in the disputes. And it has a new system that it's developing, which is intended with the benefit of ChatGPT to assist with the negotiation and mediation. For instance, moderating an inflammatory comment that might be made in a mediation context, it'll moderate it to soften and take the emotion out. May or may not be desirable, but I guess from the UAE's perspective is what is the breadth we want to go and what's the depth we want to go? And then there's the ultimate question, what role could an AI system have in a judgment?
Thank you, thank you. Anna, I have the most important question for you. So you work for the World Justice Project, okay? So you have the world in your work, and you work with data. You're the director for analytics, for data analytics. Is it possible to achieve justice across borders based on nationalized databases? I know you are interested in people-centered justice as well. Perhaps you can tell us a little bit about that, the role of data in enabling an effective and efficient judicial system.
Well, thank you very much for inviting me on behalf of the World Justice Project. I'm very happy to be here. Let me bring a new perspective to this. When we were thinking about the topic of this panel, about reimagined justice and what is exactly what we need to achieve justice across countries, which is the main challenge, right? Accounting for that variation. What I believe is that, as other panelists have said here, is this is going too fast, more faster than our minds can get. So we really need to think faster if we want to control that technology. For that, for achieving justice, we need to think, what is the next step that we need to achieve? So it's not only processing massive volume of data as we are doing right now. It's also thinking how we can integrate judicial rulings with other sectors. Because the main problem to achieve that justice is that inside governments, even the most capable ones, I'm sure UAE, which is the model to follow, especially in prosecution and law enforcement, I'm sure you also face problems of integration, of how sectors inside the government communicate. So one of the proposals that we have is not only to analyze this data on knowing how judges are deciding, what are the bias, because we need to understand their own bias to then detect the bias in the system. But it's not only analyzing these massive volumes of rulings, it's also seeing how these rulings will be enforced. And that is the challenge. I think one of the panelists in the morning mentioned that enforcement is the hardest task. So if we don't know how, when a judge is handing a ruling, if that ruling is going to be enforced, then justice won't be delivered. And what is happening is that sometimes judges make powerful decisions that change lives, but those decisions are delayed. And when justice is delayed, justice is denied. So we really need to make sure that governments are integrating different types of data, that judges are included at the earliest stage of the designing process, that communities, like vulnerable but also elites, are also integrated. It's not just few players controlling these processes.
Thank you, thank you. I'll come back to you. Maybe it's a pushback question. Regarding the implications of the cost of adopting and integrating all these technologies into judicial systems, as we discussed earlier, especially around lunch, less privileged countries don't have the resources to adopt all these new technologies, be it the infrastructure, the training, the data, etc. And going back maybe to the title of this session, the reimagining. If you were to reimagine or imagine the world in 10 years from now, what kind of imbalances and inequities that might arise from the use of emerging tech, not only AI, but also blockchain, smart contracts, etc., in the efficiency and effectiveness of judicial systems between the poor and the rich?
Thank you, Sami, for this question. And just maybe to also share what has been previously said by Anna is that digital literacy is extremely important for judges so they know how to do it. However, it's not only for judges to take responsibility, it's also for the state to ensure that the judgments which are taking place either on the name of the nation or on the name of people and there are sufficient, resources, sufficient capacity for judges to operate freely with independence, but also to use their maximum capacity. Now the question, if we are looking, if we check the cases which kind of follow up AI used cases. So we can check the most countries and most prominent cases are coming here from Netherlands, from Anna's motherland, from Colombia. And we can see that the problem there is that in most problematic so-called cases, the AI tools, LLM tools were used, and those tools that were used were open sources tools, that was not centralized, that were not purchased or procured by the authorities. So judges, just in order to simplify their life, which should be praised, but in the meantime, again, they use sources which cannot be reliable, cannot be trustful, and trust is, I think, a maxim from this morning session. So that's why when we are coming to countries I mentioned, but majority of countries in this region, in Europe, in Latin America, in Caribbean, I don't know, Southeast Asia, countries need to have access, and then perhaps some of international players could be of support. And for me, as a provider of technical assistance, it's of highest importance, because when we are kind of a supporting country, we should also ensure that this country has access. And trust me, and here are the provider, here are the representatives of law firm, firms that are dealing and creating these algorithms. We should try that it is accessible, and we should ensure that those regulators or authorities which are instructing different branches of power of using this or that technology, this technology should be reliable and accessible, because otherwise, when we are talking about crimes, these crimes never have, very limited number of crimes have only national, let's say, boundaries. It always goes further, and when it goes further, if whatever you will do in EAA, if there is something problematic that is happening in, I don't know, country X, your efforts, your resources spent on these topics will be lost. We'll have, we have these issues with mutual legal assistance issues where countries are not providing sometimes or are willing to provide, but sometimes they are incapable of providing. We could face the same situation. So that's why we need uniform approach, and we need really support of those jurisdictions where these issues, they're ready to accept, they're ready to move forward, but they need some support in this regard. And I think it's really intrinsic, it's really important in this field. Thank you.
Very good. Thank you. Again, follow up on this. I'll ask you, Professor Policino, sorry. Do you see AI and blockchain in particular, because I'm thinking of the smart contracts again, enhancing the collaboration between countries, or diminishing the prospect of collaboration due to the adoption of different regulatory philosophies or approaches to these technologies?
So this is an interesting question. In a way, implies, on the one hand, to think to, again, local values, cultural values that are for sure different. And then AI, for example, that in a way it's for sure something that it's based, this is very important for me, it's not based on automation. So it's not algorithm efficiency, it's based on autonomy. What does it mean, autonomy? Autonomy means, in Kant words, self-governance. If you read the first definition of AI Act, it speaks about different levels of autonomy. Autonomy implies the possibility to work also without the human intervention. If this is the statement, and this is the statement, at least as far as the generative AI is concerned, it's possible to find a way for cooperation among states in order to assess this issue from a mutual learning perspective. I think it's possible, but in order to do it, what is very important is to be open to also, in a way, not only teach, but learn. Let me do an example, a stupid example. European Court of Justice, the Court of European Union, is a very powerful court, but yes, something to learn from other courts. I give you an example, a stupid example, and I will close because I see that the time is over. I want my colleagues to give the floor. The Supreme Court of the United States interpreted one provision that was written in 1791. Let me repeat, 1791, Fourth Amendment, in order to protect data privacy, in particular big data. We are speaking about a provision that has nothing to do with privacy, but with physical trespass, is interpreted in a way that is very open to new technology. What does it mean? It means that we can learn from different experience, in a way building a kind of project, and now we have, for the first time, a new treaty. It's the Treaty of the Council of Europe on Artificial Intelligence. They're trying to build exactly on this, on the common humus. That doesn't mean to reject difference, but it means to accept difference and despite the difference to find a common floor.
Again, thank you, and indeed, for the sake of time, I'm going to ask two last questions. First, you, David, and then I'll come back to Anna. David, how do you see these technologies changing the practice and of the legal profession as an office or as an individual?
Fundamentally, Altamimi has a number of emerging tech tools that we bring to our client matters each and every day. If I was a client, I'd want my matter handled in the quickest and most cost-effective manner possible, and I think it's my professional responsibility that if I have a tool available to me that can assist my client in that regard, it's my responsibility to deploy it. And so that's leading to a significant shift in the way we do business and how we deliver it to our clients. It's affecting things as simple as our engagement terms. And I would regard it as the most profound change since email. And it's much more profound than email.
All right, great, thank you. And the last statement will go to you, actually, Anna. What kind of mind shift, of change of mind, or in mindset, I should say, that would be required for organizations, legal organizations, to make the best use of all these new technologies that are made available to us?
Before replying to your question, I just want to react for what David says. Last year, we conduct the first subnational project in the European Union. We survey more than 5,000 people and 8,000 lawyers across different specialties. And what we found is that there is a huge gap for lawyers to use digital tools. So they agree, and it's a similar statistic that they gave in the morning. 60% in average, they believe that digital tools are improving access to justice. But 30% believes that are hard to use. And we are talking about lawyers, educated professionals.
So it's a segue for the mindset.
Yes.
Because then we have to wrap up.
And then for the mindset, which is super quickly, is we need to change the mentality. This is not about digitalization. This is about how justice is being transformed through experiences. For judges who needs to get digital capable to interact with these tools, but also to adopting people-centered justice approach. With my organization, we are working with the OECD to develop like a people-centered justice approach, which means that we cannot only focus in process, how many courts, how many judges, what is the budget. We also need to focus on outcomes. If people perceive fairness, if they are trusting in the judiciary. So this is the change of mentality that goes hand by hand. It's not only technology, it's also human interaction.
The quality of the outcome. So with that, I'd like to thank you all for your attention. We hope that our session was a little bit different from those before us. And thank you very much, dear panelists, for sharing this very interesting conversation with us and with the audience. Thank you. The time is over. Thanks.